Good afternoon. The Senate Judiciary and Public Safety Committee will come to order. We do have a quorum. Today is Wednesday, February 26th, 2025. Members, today we have an informational hearing on Brady-Giglio issues. As you can see, there's a lot of interest, and I know there's been a lot of work between various stakeholder groups leading up to today's hearing. We are not going to take any action on any specific bills, but we thought it was really important to have an open public conversation about the issues here, which are important for our Constitution, important for public confidence and trust in the outcomes in the justice system, and important for all the individuals that participate in the justice system in one way or another. So we are glad to have this opportunity to do this. Members, in your packet, you're going to find a comparison of the formal proposals that have Senate file jackets prepared by Senate Counsel. There's a letter from the American Civil Liberties Union, a letter from the League of Minnesota Cities, and a letter, I believe, from the Hennepin County Attorney's Office as well. We're also going to be hearing, I know, testimony from a number of these folks. Also, all the testimony, I think, is going to be in person unless one potential testifier schedule frees up and he may be able to join us by Zoom. At the end of the hearing, we're just going to adjourn without taking any action. I encourage members to take good notes, think through this stuff. This is going to come back before the committee at some point. It's my goal to take some action this year because a lot of people want some clarity on what the rules and the policies will be. The nub, of course, is clarifying what's it going to look like. So that's what we're here to do today. We're going to start with Senator Seeberger's bill, Senate File 599. Members, we're going to be handing out the House delete everything language, which is the current product of stakeholder conversations. And this will become the basis for the conversation today from Senator Seeberger's perspective. Senator Seeberger can let us know who all has been involved and where she's at. So thank you, Senator Seeberger. Why don't you go ahead? And you can bring the testifiers up whenever you're ready to.
Thank you. My two testifiers will be Kevin Beck and Mark Schneider. Invite them to come forward. While they're coming forward, I want to thank Chair Latz and members of the committee for hearing Senate File 599. And I would encourage folks to take a look at the House delete everything amendment that's being passed out. Senate File 599 represents efforts made by the MPPOA to address the issue, the Brady-Giglio issue that we're here to talk about today. Concurrently with that, and at the same time, the chiefs of police worked on their own version, which is the second bill to be heard today. But in the interim, and at everyone's encouragement, the two sides got together and managed to come up with an agreement, which is the House delete everything amendment that's being passed out to you today. So my testifiers here will be focusing on this delete everything amendment, not the text of 599 that's in front of you, because this represents the agreement that the chiefs and MPPOA have come to when it comes to Brady-Giglio. I'm not going to take a lot of time talking about it. I'm going to let my testifiers take over, and I'd invite Mr. Beck to go ahead and address the committee. Mr. Beck. Yep.
Mr. Beck, welcome to the committee. Go ahead and introduce yourself and your affiliation and then present your testimony.
Thank you, Chair, members of the committee. My name is Kevin Beck. I am a labor attorney in St. Paul. I represent approximately a half dozen public employee unions in all kind of aspects of public employment in the state of Minnesota, roughly 13,000 members, top to bottom, east to west. I'm here to testify on this bill and kind of two issues, as I see it. This is a due process issue for public employees who have a constitutional right to continued employment with due process, meaning notice and opportunity to respond. And the way that the Brady system is set up currently, they don't have that. And I have a real life example in an arbitration case I did, a labor arbitration case, where an officer was designated a Brady officer based on conduct that had occurred 14 years earlier, and 2 instances that occurred 14 years earlier, 1 instance that occurred 19 months earlier, from a newly elected county attorney that he just so happened to oppose in the contested election. She was sworn in and promptly designated him a Brady officer based on these 2 incidents from 14 years ago, 1 incident from 19 months prior. And I would note, in those intervening 14 years, he had testified repeatedly for multiple jurisdictions and had never been designated Brady by the city municipal prosecutors, by neighboring county attorneys, by the assistant U.S. attorney who we prosecuted for, or who we testified for. She takes office, designates Brady. The city pushed back and said, we don't think that that's warranted. She said no. Started out as, you're just a Brady officer, we'll take it case by case. When the city pushed back, it turned into, now you are not allowed to testify in any case that the county attorney prosecutes, and any case that has been charged that he has touched, they will dismiss. The city pushed back again, pointing out inaccuracies and inconsistencies in the determination of the Brady designation, asked for clarification, asked for further review. The response they got back was, quote, I've made my decision, I will not be changing it. Officer had no recourse. He has no ability to challenge that, to get that in front of a judge who would ultimately see it anyways on a Brady case in an in-camera review. City fired him. Said we don't have a spot for somebody who can't testify and who will not get cases charged out. Fought it through arbitration. The arbitrator wouldn't change it. The arbitrator found that whatever the reasoning behind the county attorney's decision is beyond the scope of my authority as a labor arbitrator. The effect of the county attorney's decision renders the grievant unable to perform the essential duties of a police officer. In effect, the city didn't agree with discipline for the underlying reason for discharge. The sole reason was the county attorney's decision not to prosecute cases. Motivation behind that, we can all speculate, but the important thing is what this bill will do is it will provide a mechanism to challenge that decision in front of a judge who's in the best position to make that determination. And more importantly, or from a labor perspective, it will prohibit an employer from terminating solely on the basis of Brady designation. It will not prevent the employer from making any determination based on the underlying conduct and providing any kind of level of discipline based on the underlying conduct. That's all I wanted to say. Thank you for your time.
Thank you, Mr. Beck. And what we'll do is we'll take the 2 testifiers here, then we'll see if there are any questions for either of them, and then we'll bring up the other testifiers after that.
Great.
Mr. Schneider.
Thank you, Chairman Latz. My name is Mark Schneider. I'm currently General Counsel at Law Enforcement Labor Services. Prior to that, I was in private practice with a firm, and we handled municipal prosecution. So in addition to my work on the labor side and employment side of things, representing law enforcement and other employees, I've also had the opportunity to prosecute for almost 30 years. And I had to address Brady-Giglio issues and see how to proceed with those and how to disclose and what to disclose to defense counsel and to non-represented defendants. This is not a bill to shield the truth or to prevent a fair trial. In fact, we recognize that the utmost important thing in the criminal justice system is a fair trial. It is a fair trial for the criminal defendant. It is a fair trial for the citizens of the state of Minnesota. It is a fair trial for the witnesses who are called to testify in that matter. And with that said, our bill does not seek to hide the ball or to somehow allow or encourage officers to not testify, contrary to several assertions, or not to be able to testify or to have something hanging over their head. What we're trying to do here, and when the Post Board amended their rules almost 2 years ago now, about a year and a half ago now, their original version of the new bill, or the new rule, new rules was to say if you are a Brady impaired officer, you need to disclose that to the Post Board. That may prevent you from becoming licensed in the first instance, and it may prevent you from remaining licensed in the instance if you're already licensed. And what came to light at the post hearings was that there is no uniform policy in the 87 counties in the state of Minnesota. And because of that and the arguments we made and others made, even the County Attorneys Association made, that because there is no uniform policy, a rule in front of with the post board regarding licensing is not appropriate where there's just a blanket prohibition for Brady impairment. And that brings us before your committee here today. From the labor side, what we are seeking is recognition not only that there are collective bargaining agreements and grievance procedures, while recognizing the duty of prosecutors to disclose information to the criminal defendants, we also need to be aware of the fact that not all information is Brady material. And again, that Brady applies not only to licensed peace officers, but to other witnesses who are called to testify by the prosecutor. There's an obligation to disclose impeachment and other evidence or exculpatory evidence, even for non-police witnesses. And under the terms of the bill, what we're asking for or seeking is a uniform procedure, a process that allows an officer to be placed on notice that they are or will be or can be designated as Brady impaired, and an opportunity for that officer or that correctional officer, licensed officer, or whomever to present or to determine why are they on this Brady list. And I hesitate to use the term Brady list because I know there's some pushback on that, but that's the generic reference. But a Brady designation, there is no opportunity for an officer to address their placement on as designated as Brady impaired. And importantly, it puts the chiefs in a tough spot too, or CLEOs, sheriffs and chiefs in the state of Minnesota, in terms of when is somebody Brady impaired? Is that going to affect their terms and conditions of employment? How do we make that determination? And one of the most important aspects of our bill is the fact that a Brady designation cannot and should not be the sole basis for termination. And the reason for that is there is no due process for the officer in terms of being placed on that list or being designated as Brady impaired. There are rights under the collective bargaining agreement to grieve that termination and to ultimately end up in an arbitration or a veteran's preference hearing or similar hearing. But by then, it's too late. They're scarred. The scarlet letter is there that they're Brady impaired and they've lost their job and now they have to fight to get it back. I have been involved in arbitrations, grievances, and situations where officers are designated as Brady impaired without the opportunity to address that issue up front. They're forced to argue it later on after being off work for 12 months, 16 months, 2 years. I most recently had an arbitration here where the main basis for a termination was Brady impairment. But that did not preclude that agency from doing an internal affairs investigation and us going through the grievance process in order to determine whether or not that was factually appropriate or supported by the law. And it's under those auspices for labor and also for recognizing the obligations of prosecutors, the spots of the chiefs and the sheriffs in order to create a uniform system that would allow everybody to receive fairness under our Constitution, under the laws, under the rules of criminal procedure. And with that, I would end my comments. Thank you.
All right, thank you, Mr. Schneider. Are there any questions specifically for these two witnesses while they're at the table? Members of the committee? Senator Kroon.
Thank you, Mr. Chair. You mentioned that the bill has a provision that doesn't allow for an officer to be terminated for the sole reason of being on the list. I haven't had a chance to see that, but how is that enforced if you have a county attorney who is being rigid and simply won't allow that officer to testify in court? I imagine with large agencies, maybe that is doable, but maybe not with small agencies. So how does your bill address that?
Senator Seeberger.
I'd be happy to respond.
Yeah, I'll turn it over to Mr. Beck.
Thank you,
Mr.
Senator.
Beck.
Thank you, Chair. Senator Kroon, that's the crux of it, right? Is that it effectively places The bill would place control of disciplinary decisions, which are, whether it's a sheriff's office or a police department, the department head, the CLEO, the chief law enforcement officer, makes those decisions under a collective bargaining agreement. It's a just cause standard. With the way it works currently is it's abdicated to a third-party prosecutor to kind of decide when and where they're going to kind of exercise their authority to effectively discipline an officer. And the Cloquet case that I referenced shows that. It shows that trajectory of when the county attorney didn't get what they wanted in terms of discipline from the city, it escalated. And there's nothing currently as it stands in Brady that prohibits an officer from testifying. There is nothing. That is a prosecutorial decision that is not required. What is required under the Constitution and under the cases is disclosure of potentially exculpatory evidence so that a court can do an in-camera review and make a decision of whether or not that will even be allowed to be presented in front of the jury. And if it does, they can still testify, they're just subject to impeachment. So this idea that a prosecutor can just blanketly prohibit somebody from testifying is entirely of their own accord. And this would help address that. And so like in this Cloquet case, I'm sorry to be long-winded, initially the assistant county attorney who was doing trial prep categorized this as a low-level Brady that we'll just work through on a case-by-case basis and we'll fight it. And then it escalated up to no call, no cases. So I hope that answered the question. Thank you. If it didn't, I'm happy to elaborate.
Mr. Chair, I believe Mr. Schneider also has a response to that.
Mr. Schneider.
Thank you, Mr. Chair. Senator, our bill includes language not only that the CLEO or the law enforcement agency can look at grievances or internal investigations based on the conduct underlying the Brady designation, but the bill, and I think this is important, is it's a proactive bill. So we're not reacting to a specific case, a criminal case. We're not reacting to this scenario. And what I mean by that, we're proactive in that the county attorney, as part of their duty and obligation, should review these files and concerning licensed or other peace officers and be proactive determining whether or not they're Brady impaired before there's a criminal matter set for jury trial. And then the process that would apply under our proposed bill would then kick in, so to speak, and there would be the availability to reconsider, to contest, and to seek ultimately judicial review, which is the case in many counties now. I know there's outstate counties and metro counties that are assigning specific Brady attorneys within their offices to handle these Brady issues now, and that, in fact, one county has assigned a specific judge to hear all Brady issues. So essentially, our bill is trying to seek uniformity and go through that process to protect everybody's rights. Thank you.
Senator Clark.
Thank you for this, and appreciate the pursuit for uniformity. Picking up on the dismissal for solely Brady determination, do we have many examples of that? I heard mainly determined by, but do we have examples of people solely being dismissed for Brady determination besides your Cloquet example?
Chair.
Mr. Beck.
Senator Clark. I'm trying to think. I am personally aware of at least one other one where that is the case, that didn't go to arbitration because the equation or the formula is oftentimes in these departments, if they're not able, if you're not able to testify and you're not able to do police work, what do? And if a county attorney is making that decision for the chief or for the sheriff, then it's tough. And so a lot of times what I've experienced in those circumstances is they go away without a grievance, which is unfortunate because that's kind of I would say, an abandonment of their constitutional right as a public employee to continued employment with due process. And that's what this bill, I think, aims to address, is to give an officer or any witness for that matter who is a member of a union and has those rights, the ability to challenge those. And so that is the hope, is that it will address that. And I would also posit, if the conduct is so egregious that that officer is not allowed, cannot testify, cannot charge cases, that probably forms the basis for discipline, independently of the Brady designation exclusively. Thank you.
Senator Clark.
I'm just trying, thank you, Chair Latz, and Testifiers. I'm just trying to think through if there are instances or where, what you were saying, where it could be separately done, or if it is sort of bound together. And so that's what I'm going to continue to listen for in the testifying. Thank you.
All right, thank you, Mr. Schneider. Mr. Beck.
Thank you, Chair, members of the committee.
So, I think Senator Seeberger, before you go, could you just give us an outline of the delete everything amendments terms?
Thank you, Mr. Chair. I'd be happy to do that, but I think there's others who maybe could speak to it further. I just received this. I've been involved in the, or advised of the discussions between the various, between the chiefs and the MPPOA, but not directly involved. And I'm wondering if there's someone from MPPOA who could answer the chair's question.
Anyone involved in the discussions that could just walk us briefly through the bill itself? Mr. Schneider.
Chairman Latz, members of the committee, essentially the Delito bill that's now in front of you or will be in front of you contains many of the same provisions that the earlier bill did, with a couple of exceptions. And some of those are noted in the Senate memo that was submitted as part of this committee hearing. One would be the fact that it would not be Brady impaired material or subject an officer to Brady designation if there's an internal investigation, and the results of that investigation is either exoneration, not substantiated, unintentional, or mistake. And the reason for that is that Brady and the Giglio line of cases, to a large measure, talk about not only evidence that is favorable or exculpatory, but evidence that is material. The other major changes to the original iteration of the bill included a provision for reconsideration by the affected officer in terms of not only in front of the prosecuting agency, but if the prosecuting agency maintains its position, the officer can then proceed to district court for de novo review by a district court judge in order to determine the viability and the applicability of the Brady designation and whether it meets factually or legally placement as a Brady designated officer. And that in turn would not only protect the due process rights of the officer, but also, and most importantly, the disclosure obligation of the prosecutor. And I am not discounting that. That is a serious obligation. Prosecutors are not to win at all costs. As we all know, it's to do justice. And like I said, I did that for 30-some years, and we took that, and I know every county attorney that I've talked to or city municipal prosecutor I've dealt with takes that obligation very seriously. So with that said, those are essentially the new points of the deleted bill, in addition to the earlier provisions which allow for review, not preventing a CLEO or a chief or a sheriff from further investigating internally the underlying conduct, and yet understanding and protecting the rights of all those involved.
So, Mr. Schneider, the definition on page 1 of the delete everything, the DE1, is that adapted from the Supreme Court decisions directly, or is that modified in some way?
It essentially is a reflection of what case law has indicated in terms of truthfulness, criminal convictions, candor issues, and I understand that might be a broad descriptor, but that is kind of the direction we have received, or that the U.S. Supreme Court and other courts have steered us in terms of evaluating the definition phrases or terms in this proposed bill. Similarly, the Post Board in their rules, and 6700.1600 is the standard of conduct rule, they made more particular what they deemed to be Brady impairment type issues in terms of intentional mishandling of evidence, or intentional or untruthfulness or credibility issues or intentionally acting inappropriately, recognizing that mistakes do happen. Case in point, I'm an officer, at the end of my shift, I find a baggie of pot on the driver of a vehicle. I take that baggie, I give the driver a citation, and I forget to input that bag of pot into evidence. When I show up for work the next day, I do it. Well, by policy, it's a technical violation because I did not tag and file that evidence right away. But it certainly was not an intentional mishandling of evidence. So it's those issues that become, I think, ever important for everybody to have an avenue to review.
Members, I'll call your attention to subdivision 2, which classifies agency data on these in Chapter 13 as private data on individuals. And then subdivision 3 provides for the officers to get copies of their personnel file and training records as a part of this process. Subdivision 4 does have that sole discharge provision in paragraph A, but follows up by authorizing investigation for disciplinary proceedings as well. And then subdivision 5 seems to contain an awful lot here of the agency policy. Mr. Schneider, could you walk us through that policy for us?
Yes, thank you, Chairman Lance, members of the committee. This essentially is the process or the uniform process that is being proposed through this bill. Number one is the prosecutor giving the peace officer and the peace officer's employer notice, written notice, when the officer's credibility has been discussed in a judicial order. And where that becomes ever more important is on a couple of levels. Number one, the CLEO, the chief or the sheriff, wants to know when there is a concern about one of their employees testifying in a pre-hearing or pretrial evidentiary issue. And I would also respectfully submit the officer wants to know that. The officer wants to know why a judge made this credibility determination, what was it based on, and how was it addressed by the prosecutor. So again, that's just being transparent, making sure everybody's notified when there has been a concern or a finding by a court. And then the bill goes on to continue that, requiring a prosecuting agency to make a Brady-Giglio designation and to adopt a policy along those lines that includes the criteria outlined in those subparagraphs. And again, that touches upon the internal investigations, finding of the internal investigations, and then providing written notice to the involved officer. And again, this goes to the ability and to ensure that a Brady designation is appropriate. It's not there in order to hide transparency. It's not there to interfere or to somehow up the rights of the officer over the defendant or somebody charged with the crime. It's there to make certain, not only for the county attorney, but for the officer, but for the employing agency, the chiefs and the sheriffs, to make certain that everybody's on the same page and that this officer should be Brady impaired designated. And then the balance of that section or subdivision goes on to talk about reconsideration, the process to effectuate that, and information that would be exchanged or available, and then ultimately review by a district court to ensure, number one, the policy was followed, and in number two, the court would review de novo the advisability or the proper placement of Brady-Giglio designation on a particular officer.
All right. Thank you, Mr. Schneider. All right. Let's move on to Senate File 1813 then. Senator Westlin. And I think before we bring testifiers up there, we'll ask Senator Westlin to provide us with a brief summary of this bill, unless one of the testifiers is going to do that on her behalf.
Thank you, Mr. Chair
Senator
and
Westlin.
members. I think it might help to take a brief step backwards. I'm sure everybody in this room has heard the term Brady-Giglio, but just to establish a bit of background on this, I think it's important to provide an explanation of what Brady-Giglio actually means. The U.S. Constitution guarantees the right to a fair trial if you're accused of a crime, and part of ensuring that right means that during the discovery process, prosecutors must disclose evidence they have that might exonerate the accused. Prosecutors also must reveal if they are using witnesses that are potentially impeachable, meaning their testimony may or may not be credible. The Brady-Giglio Protocol and its progeny refers to Supreme Court decisions that help protect the right to a fair trial that is guaranteed under the U.S. Constitution. Brady-Giglio protocols seek the cooperation of law enforcement officers in gathering information deemed Brady-Giglio and disclosing that to the court when the material is relevant. Looking at the bill that is before you today, there are likely some similarities and, as council has noted, some differences between Senator Seeberger's bill and my bill. But what I would highlight for everyone today is I think the objective, really, as you noted in your opening remarks, Mr. Chair, is to address this issue. We have heard from the prior testifiers that there are issues with uniformity. There is a lack of policy throughout our state that makes it very difficult in 87 counties to make sure that there is compliance with the constitutional requirement for the prosecutor to provide evidence that may be exculpatory or that may be impeachable, that may impeach a witness. So it is important that somehow or another this year, we reach some conclusion. And from my perspective, that includes hearing from all stakeholders. I have had a number of meetings and will continue to have meetings. And ultimately, I think to work with Senator Seeberger along with the stakeholders to make sure that we come up with something this year that addresses the many, many concerns that have been brought forward. Looking specifically at my bill, Mr. Chair, it does provide a framework for how prosecuting agencies should fulfill their responsibility as it relates to Brady-Giglio. The bill does three things. It provides guidance to prosecuting agencies for the collection of potential Brady-Giglio data in cooperation with law enforcement agencies. It provides law enforcement officers with a process for seeking reconsideration when a prosecuting agency applies the Brady-Giglio designation on the law enforcement officer. And it requires the prosecutor or the prosecuting agency to notify the law enforcement agency when the court refers to an officer as not credible in a court proceeding. This language was the result of work on the part of a number of stakeholders. Again, the intention, I believe, on the part of all interested parties is to try to come up with a uniform and a clear process to ensure that prosecutors are fulfilling their constitutional obligation, that law enforcement officers do have the opportunity to access due process when they are being put on lists or being designated as being Brady impaired, that they have the opportunity to have that designation reconsidered. I do have a couple of testifiers with me here today, Mr. Chair. Andrew Draper, who is the city prosecutor for the city of Maple Grove, and also Maple Grove Police Chief Eric Werner. And I would invite them up at this time, if that's okay with you, Mr. Chair.
Sure, come on forward. So coming forward, you need to just tell Senator Westlin, your bill, I hate the case, now with the read everything, Senator Seeberger, appears to be
Correct. There have been some conversations. I understand that one of the main differences, and it may not be the only one because I haven't gone through the side-by-side with the delete, but I think one of the differences is my bill does not include the language that the Brady-Giglio designation cannot be the sole reason for termination of employment. I think that was one of the primary points of contention between some of the stakeholder groups, but certainly I think my testifiers could also enlighten us on that point. So I think we'll have Mr. Draper go first.
Okay, thank you. Mr. Draper, if you could just start by identifying yourself for the committee and then proceed with your testimony.
Thank you, Senator. My name is Andrew Draper. I am the city prosecutor for Maple Grove. I started my career as an assistant public defender. I've worked as an assistant state attorney for the state of Florida. I also have worked as a privately retained criminal defense attorney. Right now, I sit on our city's Brady Committee. I'm part of the Brady Pilot Project with the Hennepin County Attorney's Office, and I have dealt with the ever-evolving landscape of Brady-Giglio throughout my entire career. The cornerstone of the holdings of Brady versus Maryland and Giglio versus the United States is the protection of due process. Specifically, if you look at the Giglio case, this was back in 1972. It was an opinion from the Supreme Court, basically, that a state's witness, that was a non-law enforcement witness, was offered preferential treatment or immunity for their testimony. This had no involvement with police credibility whatsoever, and I think that's important to note that within that 50 years, it has now evolved from what that testimony was to litigation in our district courts, basically regarding small instances of mistakes by officers, such as a mistake in a motor vehicle inventory. The main crux of those opinions have basically given due process, and the main holdings of those opinions have been due process. And there have been several pivotal moments that have continued to shape what that due process looks like. We're right now, again, at a point, one of those pivotal points for due process. However, this isn't due process in terms of a criminal defendant, but it is for ones that we have left behind. And it is those women and men of law enforcement community that protect our communities that have not been afforded due process with Brady and with Giglio. The well-known case of Holman versus the County of Carlton, that is the Cloquet case that was previously mentioned, has caused significant concern as it has exemplified the power of a prosecutor once they put somebody on a Brady list. Regardless of whether the underlying facts of that case were deserving of the outcome, it showed this extreme power that a prosecutor can have by designating an officer Brady or putting them on a Brady list. In my current position, I've worked with our department and the officers who are having their private data sought through court order. In each of these instances, it has tied up the court in needless litigation and has resulted with the court noting that the data being sought was nowhere close to Brady-Giglio. This was an example of an officer from the Maple Grove Police Department that made a mistake during an inventory search, and once that was brought before an in-camera review, the judge said that it was not Brady material, and he emphasized that it wasn't even close. That case also was important because the defendant in that case was in custody, and that Brady argument basically cost 2 weeks around approximately of that defendant being continued to be held in custody while they were going through this in-camera review of something that was ultimately determined not to be Brady-Giglio evidence. Senate File 1813 gives officers this due process, while it specifically ensures that the current Brady-Giglio disclosure standards for prosecutors remain unaffected, and that is noted in Subdivision 5. As a prosecutor, I know that a passage of this bill or any similar bill will give me extra work. It will impact my work in making sure, that I am working with law enforcement in that capacity if there is any Brady designations. It would also impact my prosecutorial discretion because it will allow agencies to challenge and to question if I were to choose to create or maintain a Brady list in those decisions. However, understanding that those could potentially be consequences of this bill, I still want to voice my support, as I believe that if the decisions of Brady and Giglio are there to support due process, that those involved in the criminal justice system should have it, and that does include law enforcement. Thank you.
Thank you, Mr. Draper. Chief Werner.
Yep. Good afternoon, Mr. Chair, members of the committee. I'm Eric Winter, the Chief of Police for the City of Maple Grove. I'm also the Minnesota representative to the International Association of Chiefs of Police, and I'm also a former president of our State Chiefs Association. For several years, the Brady-Giglio topic and legislation has been a priority for our chiefs. The information presented today is informed by input and discussions with chiefs, attorneys from across the country, and discussion with Minnesota county attorneys, labor attorneys, and local prosecutors. Minnesota chiefs are committed to and have fulfilled their affirmative duty to prosecutors of disclosing any exculpatory material for Brady purposes. So on behalf of our over 300 Minnesota police chiefs, we know that this bill proposes the necessary requirements to ensure a transparent system for the chiefs and prosecutors for the following reasons. Number one, the bill provides a uniform system for all 87 counties, beginning with a clear definition of Brady material for county attorneys and local prosecutors. Number two, due process is established for a police officer and their employing agency if an officer is considered for or is being placed on a Brady list, flagged as a Brady officer, or designated Brady impaired by a prosecutor. And number three, the bill requires coordination between prosecutors and police chiefs to review officer files and enter into agreement to review summary information of non-public data. A process that has worked in the past with the chiefs in our county that won it, but was intentionally abandoned by our county attorney. I want to finish with why the Brady topic is of such importance for the chiefs to seek a legislative solution. The decision to designate officer Brady impaired rests solely on a prosecutor and can have career-ending consequences for an officer, as we've heard today. The prosecutor's unchecked authority is concerning when the prosecutor makes the wrong decision or demonstrates other motives, and I have some examples. And Andrew Draper alluded to it. A Maple Grove officer is designated Brady impaired by our county prosecutor without notification to the officer or myself. On request by myself and the city for judicial review, the decision was overturned, and the judge stated the review reveals nothing that either is or could reasonably lead to admissible evidence in the case, or as the judge stated in court, not even close. I thought the matter was settled. The county attorney continued in another case to state the same officer was Brady impaired based on the same information. A separate judge again overturned the decision. Last week, the Minnesota House Public Safety Committee received testimony on the Cloquet case that I believe we just heard today about an officer being designated Brady impaired for potentially political motives, and the officer lost their job. Officers in other states have experienced similar issues resulting in litigation against county attorneys. In fact, the state of Iowa passed similar legislation that we are proposing as a result of the lawsuits being filed. Senate File 1813 is the product of many discussions with various attorneys and other groups, as I stated in my opening. Likewise, Senator Seeberger's bill is the product of many groups working together and engaging in ongoing conversations, of which the Minnesota Chiefs of Police Association has been party to. The chiefs just want a process that allows our agencies to work with our county and local prosecutors to fulfill our duty to provide information required under Brady. As one federal prosecutor wrote about the Iowa Brady law, the Supreme Court has never said due process rights of defendants trump the due process rights of officers. Prosecutors should embrace and guard the rights of both. The chiefs support the bills because we believe they accomplish that purpose, so I ask that you consider this bill and that we continue to work together. Thank you for your time.
Thank you, Chief Warner. Do any members of the committee have questions for either of these testifiers? Senator Clark.
Thank you, Chair Latz. Just trying to get my mind around sort of the timeline on how this all works. So in terms of reconsideration, you were talking about a 2-week timeline with the Maple Grove example. Is there a typical timeline or a sort of a process that you can walk me through that includes dates, weeks, or months, and how long the reconsiderations might work?
Mr. Chair, Senator Clark, I think there's 2 timeline processes in our bill. There's the due process, if we follow that based on a policy, and that would give very specific timeline. So if information is provided to the Hennepin County or a county attorney's office, it would be Hennepin County in our case, then that timeline would start and officers would be notified. In regards to the case that Andrew Draper spoke of, that was weeks because we were caught off guard. And then we had to convene attorneys, which include labor attorneys, city attorneys, and then file for those appeals. So that's what extended that out. But I want to go back to the one provision in our bill that I talked about where it required county attorneys to work with chiefs. We had a prosecutor where we would sit down and we'd look at it and say, there's nothing in the officer's file, and then we would move on. That process was abandoned, and now we're just caught up in all these orders that we believe are unnecessary or the review that Andrew Draper spoke about.
I'm just trying to, some of this, thank you, Chair Latz, I'm still learning the process here. Thank you. Trying to understand as well recency of this. It's, it sounds like we've been implementing in Hennepin County and other places to try and get to a spot. Maybe some may say good, some may say eh. How recent are the examples, and are we in a better spot now than we were whenever this example was?
Mr. Draper.
Example, thank you, Senator Latz, committee member. Senator Clark, I believe that the case from the city of Cloquet originated in 2019. I think that the arbitration, and correct me if I'm wrong, ended in 2023. And so the end result of that case was relatively recent. The case involving the officer from the Maple Grove Police Department was, I believe, in the last year. And that part, I would like to reiterate, that process was not a 2-week process as it is laid out in this bill. That was just a result of the case having been set for trial. There was information that was relayed to the prosecutor that there could potentially be Brady-Giglio information to be disclosed. It stopped the trial while that was litigated, and that, I think it was approximately 2 weeks. That timeline was from when that Brady-Giglio notice was given, when the officer learned of it, trying to figure out, what the process was to be able to react to that, to work with the attorneys. I'm the city prosecutor. I even tried just to step in to help, as did our city attorney that does the civil work, labor attorneys. And so that was not a 2 weeks as it would be laid out in terms of a process. That was just kind of the end result or end timeline of how that happened.
Senator Clark. Okay. Senator Umuver-Benton.
Thank you, Mr. Chair. Chief Werner, you talked about a scenario where an officer, where the court determined it wasn't Brady material, and then the prosecution came back again in another case. I reached out to the St. Paul Attorney's Office, and one thing that they wanted to make clear is that these Brady-Giglio determinations are made on a case-by-case basis. And what is Brady material in one case might not be Brady material in another case. So when I hear that example, I'm thinking they're probably doing their job and ensuring that, the judge looks at that information and determines whether or not that's Brady material. So really my question, I guess, is for Mr. Draper as a prosecutor. Do you disagree with that, with what the City of St. Paul Attorney's Office says in terms of it varies on a case-by-case basis, and if so, why?
Thank you.
Mr. Draper.
Senator Lass, Senator. I don't disagree with it from a philosophical standpoint. Brady-Giglio is generally on a case-by-case basis. And if you look at the holdings, Brady generally deals with exculpatory evidence, whereas Giglio generally deals with credibility of witnesses. Credibility of witnesses, and I think that is kind of the catalyst for a lot of these bills, is case by case, but when you have a circumstance where it is almost definitive that is not a credibility issue, and when you have a judge ruling that there is no reasonable nexus of why this would be Giglio, I think that is a significant differentiating factor than, well, we have to look at this on a case-by-case basis. And I think that the point that was trying to be made there was the case that was litigated in this officer. By no means, in my interpretation of Brady-Giglio, would I have disclosed that. I did not think that that was a Brady-Giglio offense. the Hennepin County Attorney's Office had a different position and continued to litigate that issue. And that's another issue that's not, I don't believe, resolved here. However, it puts me in a pretty precarious position when the county attorney's office is disclosing Brady-Giglio on a witness that is in a lot of my cases, and I'm not, and we're having a difference opinion. And I think that's important for whenever you can have an actual set procedure for these determinations that can help kind of bridge that gap.
And Mr. Chair, if I could.
Senator Westlin.
I'll speak briefly, and then if Chief Warner wants to provide additional information. In this particular case, so if you look on lines 2.19 to 2.22, the bill states that criteria required under Clause 1 may not include conduct that is not substantiated following an investigation or individual instances of conduct determined to be unintentional by the chief law enforcement officer of the employing agency following an investigation into the matter, such as mistake, inadvertence, or neglect. And in this particular situation that you're asking about, Senator Umar-Verbaeten, that was a situation where it either was not, it was not substantiated, or it was a situation where there was mistake or inadvertence. And so that would be true from one case to the next, that it was a situation that wasn't substantiated. But Chief Warner, maybe you can provide.
Chief Warner.
Mr. Chair, Senator Westlin is correct. So the summary of what took place is there was a complaint that was filed. The officer was actually exonerated in the original complaint. As our agency does its due diligence, did what took place, and we saw this, what we believe was to be a mistake. So we took that information, we retrained the officer, and we moved on. And there was even a question of an old policy versus a new policy. As Andrew Draper says, we take the Brady-Giglio material very seriously in our agency. We meet on a regular basis if there's any issues with complaints, and this complaint was reviewed at the local prosecutor. So when we got notice at some point that the officer was placed on Brady, we were like, this cannot be. It just totally doesn't make sense, whether it's in one case or the other of what took place. And I think the judge's first reaction, if you read the order, which I presented in some testimony last year, is it was not even close. And then we go back at it again, and it's viewed as not Brady. And I think the language that was just read addresses that kind of issues.
Senator Umar-Verbaeten.
Thank you. I'm actually glad that you brought up that paragraph, because that is one of my other concerns of just preventing prosecutors from accessing this information. I think that's really their job. I'm particularly concerned about the second component of individual instances that are just determined by a chief law enforcement officer and what the checks are around that. But I know we have a number of other testifiers, and so I'll wait to hear from those folks, particularly the other prosecutors on the case-by-case basis as well.
And Mr. Chair and Senator
Westlin.
Umar-Verbaeten, we've been having conversations, and I will reiterate once again that I think it's important for those to continue, and I have appreciated you bringing some of those concerns. And certainly we want to make sure that wherever we land this year, assuming we are able to land the plane, that we make sure that we have good answers to those questions. And I do appreciate you bringing that. Thank you.
So I have a question for either of the witnesses or Senator Westlin. And this has to do with the case-by-case analysis. I'm trying to imagine a situation where this mistake relating to, for example, not inventorying the baggie of pot until the following morning, the next shift begins. I can imagine that not being relevant at all in 1, 2, or 10 cases. But in case 30, the same officer is involved in the entire pretrial issue in that case is chain of custody of the evidence, and whether that chain of custody left open room for manipulation, contamination, or anything relating to the evidence, which would end up in an evidentiary hearing and a judge making some credibility determinations about what happened with the chain of custody. In that kind of a scenario, would this failure to inventory the baggie of pot be relevant Brady-Giglio material? Or would it be forever encased as non-Brady-Giglio material, regardless of whatever new case, same officer, different analysis comes up? Mr. Draper.
Yes. Thank you, Senator Latz. I think to answer your question, generally under this bill, if it was determined to be mistake, then it would not be Brady-Giglio. I see your point as if there was a case in which there is a chain of custody. There is a lot of circumstances that would be dependent upon this, including remoteness of time and other circumstances. Think if there is a circumstance that is immediately thereafter, you could potentially disclose this as Brady, but this bill does give that officer the opportunity then to challenge that designation.
So does the bill language leave open the prosecutor's ability to get that older mistake case information and to decide whether or not to disclose that as Brady-Giglio material?
I believe it does, because I believe subdivision 5 specifically states that it doesn't absolve us from our Brady-Giglio duties. We do have a continuing duty to disclose, and I don't know if any of these subdivisions in here require that the individual agency, delete those files. And I know that Chief Warner and I have gone, when I was working with the Brady-Giglio pilot project, we went back 20 years for documented incidents. And so it doesn't take away the documented incidents or the complaint. However, this does allow officers, if a prosecutor decides you did an incorrect inventory, I'm putting you on a Brady list, to challenge whether or not that they should be designated as a Brady officer and if it should have that implications to their employment.
Yeah, what I'm trying to cross-read some of the provisions here where there's a duty to disclose on page 4, subdivision 5. But then reading that against the agency policy, starting on the bottom of page 1, it's subdivision 2, where the criteria used by the agency, and the criteria, then if you go down to line 19, may not include conduct that's mistaken, inadvertence, or neglect. So I'm a little bit concerned that there might not be consistency there in terms of what gets disclosed. And I know that's, rights of peace officers, but it has to do with the prosecuting agency's criteria. Anyway, I think it's worth a close read to make sure that we're threading the needle properly.
Yep.
The only other question I had, and maybe some of the other testifiers when we get to it are going to address this anyway, but there's a substantial difference in the definition of Brady material between the delete everything amendment that was presented under Senator Seeberger's bill in subdivision 1 on the first page, line 4, and the definition in Senate File 1813 on page 1, starting in line 12. For example, there's nothing about bias in Senator Seeberger's DE language. There's nothing about police authority or abuse of police authority in the delete everything amendment. And the DE also removed from the original bill a catch-all provision that would address anything else relating to credibility or untruthfulness. So I'm just suggesting we've got some further conversations to be had about how we define Brady-Giglio material in the first place as we kind of move forward. So with that said, Senator Westlin, is there anything else that you'd like to present as a part of Senate File 1813? And if not, we'll move on to some of the other testifiers that have signed up.
All right, thanks.
Well, thank you for your work on this, Senator Westlin, and those of you at the table as well. Appreciate it very much. Okay, so now we're going to ask the following 3 county attorney folks to come forward. Kevin Magnuson, Washington County Attorney, Brad Johnson, Anoka County Attorney, and Jonathan Holitz, Assistant St. Louis County Attorney. Appreciate you being here, especially the Assistant St. Louis County Attorney. who left snow-covered North Shore territory, northern Minnesota, come down to Barron Brown, Twin Cities metro area.
Thank you.
However you'd like to proceed, whichever one wants to go first is up to you three. Just go ahead and identify yourself for the record.
Chair Latz, may it please the committee. My name is Brad Johnson. I'm the Anoka County Attorney, and I'm here testifying for and at the request of the Minnesota County Attorneys Association. The topic we are here on today is not a new one. It goes back decades. Brady was decided, I believe, in around 1963, which is, respectfully to all here, probably before most of us were born, except for Bob Small over there. What is newer
No
is...
disrespect taken, since my birth year was 1963.
There you go. What is newer is the handling of Brady material and the evolution of various laws and individual rights. We've got the Minnesota Government Data Practices Act that you all are all well too aware of. We have the balancing of privacy rights versus rights of those accused of criminal conduct. Those issues have brought out some inconsistencies in policies that have been in force and effect over decades. They've brought out some inconsistencies in practices, not just among county attorneys, but also among county attorneys and city attorneys or local courts, or even the interrelationships between law enforcement and prosecutors. There have been some inconsistencies in how laws have been applied across our state, and there have been some inconsistencies indeed across the nation. As a result, in early 2024, the Minnesota County Attorneys Association created a statewide Brady-Giglio work group. It was chaired last year by the Sherburne County Attorney, Kathy Heaney, and this year I'm at the helm of that work group. It includes membership from Sherburne, Anoka, St. Louis, Carlton, Stearns, Candy, Ojai, Olmsted, Blue Earth, and Traverse counties. And of course, we refer to or defer in many respects to Bob Small, the executive director of MCAA, for some of his wisdom and guidance on some of these things. And also we reach out and talk to board members and the leadership at MCAA where appropriate. We've been holding monthly meetings over the past year. There have been multiple day-long drafting sessions. And the whole purpose is to draft policy resources for county attorneys across the state for recommended policies and best practices that we can then recommend to the board. And we're at that point where we have a draft before our board, and our executive committee and the board are reviewing that. I would say that working through this over the past year, it's been kind of like the 5 stages of grief. You know, there's denial, anger, bargaining, depression, and I would say we are closer to acceptance now, so I feel grateful to be able to say that to you all. The goal is to develop an approach that can be used statewide, general policy measures. Last week, we met with representatives of MPPOA, the Sheriff's Association, the Chiefs Association, the BCA, and there are others that are justice partners that we look forward to working with and continuing to collaborate with. I would note that the St. Paul City Attorney was at our board meeting and heard a report on this, and so we do definitely want to work with city attorneys on this issue. We have reviewed various bills, and I would say, out of respect for the time and the interests that are all here, none of them were prepared in collaboration with the MCAA or any representative county attorneys. There are some principles in the bills where you will hear county attorneys generally agree with those policy principles. There are other principles in the bill, in the bills of the various iterations that have been before all of you that cause great concern about the constitutionality of a particular provision or two, the concern about separation of powers and appropriate separation of powers, and the infringement on a prosecutor's ethical and constitutional obligations and responsibilities. MCAA's board met, and I am here to relay that while there are points of policy agreement with some of the legislation that is kind of working its way through the legislature, there is general opposition to any law that did not get drafted with input from county attorneys. Some matters are best left for policy, some for enhancements to rules or local practice. Some issues require better training for prosecutors, both city attorneys and county attorneys, and judges, and maybe even some defense attorneys too. That's the same thing I hear in court. There may be, and I would like there to be, some modest legislation that can be helpful to both the prosecution function and to law enforcement officers and their departments, but we must work together on that. MCAA, I want you to know, is committed to continuing collaborative efforts with our justice partners and other stakeholders who I'm sure you can imagine have an interest in this. In this process, though, it is important to remind everyone here that it is the responsibility of the prosecution function in our criminal justice system and the county attorneys in the Minnesota County Attorneys Association must be leading the way on this issue. Courts have described this duty, the Brady-Giglio duty, as a, quote, self-executing prosecution function. That means it's on our shoulders to do it. So when I see bills and laws that tell prosecutors what their policies need to be, understand that oftentimes those are issues that are already matters of policy. What I fear is the unintended consequences of putting that stuff into law because, candidly, the third-party beneficiary of that is a defendant who may seek to suppress or may seek to dismiss a case based on some policy difference or some perception that there wasn't a prosecutor that was meeting their Brady-Giglio obligation, not because they didn't meet their Brady-Giglio obligation, but because there wasn't strict compliance with the statute. I have confidence in the process that the Minnesota County Attorneys Association has undertaken and the relationships with our justice partners who we worked with last week, and that we I think are on a good path to work with continuing and going forward. Last week at our meeting, they gave us 6 points they wanted us to follow up on with them. And I spent the weekend and most of yesterday drafting responses to those 6 points. We are in the middle of working on this issue with them, and we want to continue doing that. I would say that I'm very optimistic that Minnesota is headed in the right direction, but I'm concerned a little bit about legislation that kind of changes the game in midstream while we're making better progress on this than in my career. So with that, I'll defer to my colleagues and be ready to stand for questions when they're done. Thank you.
Thank you, Mr. Johnson. Mr. Magnuson.
Thank you, Mr. Chair, Senators. Good afternoon. I am Kevin Magnuson. I am the county attorney for Washington County. I'm also on the executive committee of the MCAA, and I appreciate having the opportunity in that capacity to address you on these very important, even existential issues for prosecutors. I have to say that they can be existential for law enforcement officers as well. We understand that. And of course, they can be existential for defense counsel. So these are weighty, important issues that we're dealing with today, and I do appreciate this. We're having a lengthy information hearing on it. But this places a unique obligation on prosecutors to disclose this kind of evidence. And there's something strange about the way the Supreme Court has us get at this function, and that is it causes prosecutors to get the information from law enforcement to produce in the trial or in the case And so there's an indirect mechanism. And so that makes some of this tension sort of inevitable that we're seeing. But I listened to some of the examples at other hearings and today, and, and some of those are, concerning and at least in the general idea of what's occurring. But a lot of the things that I've heard and seen are really problems that come from law enforcement and prosecutor agencies not having a lot of trust between them, having good communication and cooperation. And I think in order for this system to work, the system that's mandated by the Supreme Court, there has to be that level there. So I'd encourage you to keep that in mind as you're thinking about what should be legislated and what should not. So we start with this Brady-Giglio list concept. And what's interesting is in the bills before you, like in so many discussions here and elsewhere, it presumes that there's a Brady-Giglio list that exists. And that suggests that the list, well, it's a synecdoche. I had to use that, Senator Latz, for you, but it stands for the whole system. This Brady-Giglio list stands for the entire system, all the data, everything, all the analysis goes in. And as a result, it's kind of a caricature. It's not a naughty list. In our case, we don't even have a list. We don't need a list. The Supreme Court does not require a list. It only requires in Giglio and progeny that there's a system of record keeping on this for this material. And so, the entire federal criminal system doesn't use a quote unquote Brady list. And that's because I think it's just wrong to think of someone as being Brady designated or it being attached or impaired, but a designation that that somehow that person is already, his credibility has already been challenged, or they're somehow damaged. What we have evidence that meets the Brady-Giglio criteria. And that evidence needs to be reviewed in light, as you've heard, the individual case and what it is you're trying to accomplish with that witness. There may be times when a person had, something in their background that may not be relevant at all, but may qualify as Brady material. That doesn't mean they're damaged. It just means that there's a disclosure requirement. And in the case of, we as a group, the MCAA understands the need for there to be due process for officers. We understand that mistakes happen. Again, I would say if you're in good communication with law enforcement and they're sharing information, you're sharing information, I think those things are reduced to a minimum. But it's really important that prosecutors have a policy. And in that policy, they've got it lays out the information, lays out what Brady-Giglio material is, it lays out their procedures, and it designates a person who's responsible for Brady-Giglio in the office. And so when there's evidence or an indication that there might be some Brady material that needs to be discussed with an officer, it's not a designation on the officer. It is really just a notification to go to your Brady-Giglio person and talk about the situation in communication with law enforcement. Usually you need updated records and that sort of thing, and work together to find out, okay, do we have a disclosure obligation, even if we don't think that it's something that's going to have to be, it's going to be, really material in the trial, or is it a situation where it's a close call, private data, for example, I should say not public data, and I'll end with this description of the process is the prosecutor then notices a in-camera review, makes a motion for an in-camera review, and that officer then who's subpoenaed to bring the material, who's in the notice, is notified, has an opportunity to participate in the process, in the determination of whether that material should even be reviewed in camera or, after review, whether it should be disclosed or not. And so there is procedural due process built into at least part of the process if it's done the way we think it should be done. So thank you very much for this opportunity, and I'll stand for questions.
Thank you, County Attorney Magnuson. Mr. Holitz, did I pronounce your last name right?
You did. Thank you, Chair.
All
Thank
right.
you, Senator Latz.
Thank you. Welcome to the committee.
Thank you. And I appreciate you acknowledging the climate difference that I've encountered today. I appreciate any sunlight, so thank you very much.
Do they still have snow on Spirit Mountain? That's
Oh,
all I
yes.
want to know.
Yeah, we're still open. Come on
All
up.
right, let the word go forward.
Go skiing, please. Thank you. My name is John Holitz. I'm the Deputy St. Louis County Attorney. I have been in the role in that office handling Brady review, determination, disclosure since 2020. I am here on behalf of the MCAA, asked to testify with my colleagues to my right. I've been given the, I guess, unenviable task of diving back into private data and talking about why private data very well could be Brady. Data that is non-public could contain things that prosecutors have to get to. Now, Chair Latz, you've already taken my one of my examples, so that'll shorten me up a little bit, but I do want to jump back in sort of where you left off. There are four larger categories in this private or non-public data where we found that data that would fall within Brady could live. Now, just as a reminder, Brady doesn't mention public or private data. That's a Minnesota law thing, and we're talking about the constitutional obligations. One place where it can be is when, let's say, an employee leaves in lieu of sustaining some discipline. Let's say an employee is under investigation and decides that they will leave employment in lieu of discipline. That underlying data, sustained or not, investigated to its fullest or not, determined by a chief to have happened or not, that underlying data still needs to go to prosecutors to be determined if it must be disclosed. So that's an area that we've got to have access to. If there's an ongoing investigation that is not completed, those speedy trial rights of the defendant are there. It doesn't matter if this employment action is going on or not for that defendant and for the prosecutor who's got to prosecute that case and who has the obligation to disclose it. So we've got to have access to review and disclose that information if necessary. We have found generally most places hiring public employees do some background investigations and do background questionnaires. Oftentimes on those they ask questions about prior discipline. Those things are helpful to a prosecutor, and that could be Brady material that a prosecutor has to look into to determine if they've got an obligation to disclose it. So we've got to have access to that material. We've got to have access to that data. Now there's this tension already that makes it harder because of the MGDPA. That already makes it harder for prosecutors to do it. So that creates some tension already. I've got leering feelings about any proposal that makes that even harder. And a lot of the proposals we've seen would make that harder for prosecutors, would make it harder for prosecutors to access the information we just have to do our job that the Constitution tells us we have to have. The fourth category, I said I had four. The fourth one is, Senator Latz, you sort of have an example off the cuff that you came up with already. I want to talk, though, about intermediate discipline, or like a coaching type behavior or a coaching type discipline. Certainly we want law enforcement to be able to correct behaviors that they see. We want them to be able to improve employees. They need to do that. We want them to do that. That's how people get better. However, just a coaching incident, maybe not rising to formal discipline, but if that data exists, that still could contain information that is Brady. Not always, and not in every case. There's still that materiality assessment that a prosecutor has to do. And it's a prosecutor who's tasked to do it, not anybody else. It's our obligation. It's our burden to do it. I'll leave you with an example. Imagine, if you will, an officer arrests one person and one person only during their shift. At the end of their shift, as they are getting out of their squad, they find contraband in there. They find something that would rise to a crime to possess. The officer then in their police report says, I know who it was who left that in my car, and I know it because I only had one person in there. And before the start of my shift, I go through and I check my squad car. And at the end of my shift, I clean my squad car. So it has to be this person. Now, imagine if that same officer has had some coaching, some written, non-public discipline that says, you don't clean your squad car. We found things left behind in your squad car. That's not Brady in every case. Failing to clean up after yourself, that's human. That's not Brady in every case. But in a particular case like that, it becomes material and it becomes something that a prosecutor has to disclose. I give you that example because it's a real example. It's one that I've encountered. So, if ultimately it's determined that some legislation is appropriate and necessary, I think that it's extremely important that MCAA, that prosecutors are part of any legislation, part of and working together to create any legislation, because we've got a unique position in this process. We hold a unique position to know what we need. So, thank you very much.
Thank you, Mr. Holitz. Senator Westlin, then Senator Clark.
Thank you, Mr. Chair, and thank you so much for being here today. As I mentioned, and I will reiterate, the hope is that, especially following this informational hearing, that this is going to precipitate further conversations. I do have to clarify a couple of things, just because I want the record to be clear. I've actually been trying to reach MCAA to engage in conversations about the bill. I had reached out to the Hennepin County Attorney's Office early February before the bill dropped, and I believe we're in the process of getting some meetings set up. So I just wanted to clear the record up, though, to say that, well, before the bill dropped, you weren't part of drafting this particular bill. My expectation, of course, would be that you would be part of that conversation and that process, and I have been trying to do that. So I just wanted to sort of clarify that record. And I would reiterate again that I think it is very clear that the constitutional obligation for prosecutors is very clear. The duty to provide exculpatory evidence, and then also evidence that would reasonably impair the credibility of a witness. And I think, as has been stated multiple times here, it is a needle we're trying to thread here. And I think we can do it as long as everyone is willing to come to the table and have conversations about concerns. But I do think there is value, as we've heard today, in trying to come up with some sort of a process that is reasonably consistent. We have the State Patrol that is operating in every county in the state of Minnesota, and they may come across different process in each one of those counties. And I am aware of the work that that your work group has been doing. I know you've been trying to tackle this issue too. So I would say let's put all that brain power together and see if we can't come up with something.
Senator Clark.
Thank you, Chair Latz. County Attorney Magnuson, you're speaking to my process and systems heart and mind, and so my day job is all about that.
I'm in trouble now, aren't I?
You're talking to an expert.
Of course not. I think we love it because it builds consistency and outcomes, trust, quality. It's doing all those things. I heard you mention, and to do that, it's really how do we make it as automatic and clear in expectations as possible. I heard you mention a need for an existence of an indirect mechanism in terms of getting information from law enforcement. Why is there that indirect, and can we make it more direct?
County Attorney Magnuson.
Thank you, Mr. Chair. It's important because it's a protection in large measure, both well, mostly for the officer, but also you want a prosecutor coming into that information that they need to have. You don't want them being somehow prejudiced in their, not so much prejudice, but just not able to evaluate for law enforcement that is providing that information. And the idea is that if you have a Brady-Giglio person who's the point person in your office, and typically this is how these things work, you get some kind of indication, or you have some kind of indication from your own preparation for trial, or just for charging for that matter, and you then go to that individual to figure out, okay, what kind of information do we already have, we don't, and that then points them to data that they have that they go look for. And sometimes, the attorney won't even know what the data is or was, or why, there was some indication that this person, in a discussion raised an issue and they just never flushed it out. So it's definitely not a designation on the person. It's a designation of data.
Senator Clark.
Chair Latz, so do you have direct access to the information? Why not?
Well, I think I'm sorry, Mr. Chair. The particular case, you've accessed obviously that information, but that information is not in some place that's accessible. All the Brady-Giglio data, for example, is not held in one database. It's accessible to everyone.
Senator Clark.
Chair Latz, but County Attorney Magnuson, if it's held by law enforcement, you are able to go see it.
Mr. Magnuson.
No, thank you. Well, typically in Washington County, yeah, because we have a very good relationship, and we'll ask, and they'll, there's a dialogue that goes through the whole process long before we even get to that point. I mean, there's discussions with us when something happens with an officer, when it happens, before, there's even a case involved typically. But yeah, I don't know if that answers your question or not.
Senator Clark.
Chair Latz, maybe it's getting at sort of multi-jurisdictional issues of you got maybe you have a good relationship with, you're going to test my Washington County geography. Maybe you got a good relationship with Stillwater and not so good with Marine on St. Croix.
Oh, no.
And not so good with Schaefer, but really good with Taylor's Falls. How do I do?
There you go. Debatable.
Stay in your lane.
I'll stay in I'll stay back I'll stay in Hennepin County. So just trying to get a better understanding, because your testifier to your right shook his head, was like, no, and
Yeah.
you said, all right, I have access. So it seems that we don't have uniformity
Well, I think
in access.
Mr. Chair.
County Attorney Magnuson.
When I say that, I say what, I should have finished the remark before I lost my train of thought. But the idea is, law enforcement holds the data. And from our standpoint, they have an obligation under, the Brady-Giglio law, federal constitutional law, to provide it. I know that there are some approaches that basically want to have, carte blanche, walk in, inspect all the records, do their own investigation of the investigators. But in this situation, because the data resides with law enforcement, it's really up to them to be providing the records and providing the information. Now, if there's something that we need, we do issue a subpoena and go through the in-camera process if we need to. So we can usually get what we need, but our policy doesn't involve us inspecting records without some cooperation.
Chair Latz, may I?
Yes, County Attorney Johnson.
Chair Latz, members of the committee, have to remember there are 87 county attorneys, and in every one of those counties there are multiple cities, and most of those cities have their own city attorneys. And there are differing interpretations of the permissibility of access to especially private and non-public data, which is really the sensitive part here. There is a part of the Minnesota Government Data Practices Act, just for your reference, it's section 13.05, subdivision 9, which talks about, I believe, the sharing of data between intergovernmental agencies. And it really says that you have to look to, if it's authorized by a state or federal law, then you can share it. So for example, during a child protection investigation, child protection investigative social workers can share data with law enforcement, and law enforcement can share data with child protection social workers because there is a separate authorizing statute under Chapter 360 or 260 E, maybe? I might be wrong on that. But at any rate, it's 260. There is no corresponding one for law enforcement officer data. And so I think, you know, different jurisdictions have dealt with that in different ways. In some jurisdictions, they have just a good trusting relationship. Others have stood up a memorandum of understanding. Others have said, you know what, we prefer a subpoena process. Because if it's being produced pursuant to a subpoena, then if there's any objection to it, there can be an opportunity to be heard on that subpoena. So that is part of the rub, and that is an area where perhaps law enforcement, and especially if there's protection of the classification of the data, and that it is protected then if there's any disclosure downstream with an appropriate protective order, there's ways that law enforcement and prosecutors, I believe, might be able to come together on that.
Just so members know, we are going to go until about 2:45 or 2:50, so we can air as much of this as we can while we have everyone here. I know some of members may have other committees or other obligations you have to get to, and I appreciate that. But let's just try to keep our questions and answers focused. We still have 3 testifiers who will be coming forward to present to the committee. We want to make sure they have opportunity to do so as well. Thank you. Senator Clark, follow up.
Chair Latz, thank you. Thank you, testifiers. I appreciate our focus on privacy of data and appropriate privacy. In terms of the, Assistant County Attorney Hollitz, in terms of privacy and accessing data, are you able to get all the coaching data that you require?
County Attorney Holitz.
Thank you, Chair. As County Attorney Johnson has said, Senator Clark, we do a data request. Yeah. And that's the way we do it. That's received by different agencies in different ways. It's always challenging when you go outside a jurisdiction you don't work in all the time, because sometimes they say, what is this and why are you doing this? Mm-hmm. But usually we can work through that. And that's the way we've done it. So with, you know, since 2020, we've had pretty decent success with that. Thank you.
Senator Limmer.
Thank you, Mr. Chair. County Attorney Johnson, you made a statement that said prosecutors must lead the way on this legislation, and you have a group or a task force that's been working on this. How long have they been working on this?
So we stood up the task force in 2024 when it was becoming clear that there were new approaches that were being tried around the state of Minnesota, and there were differences of opinion on things, and we wanted to make sure that the voices of small, medium, and large county attorneys were involved in shaping the recommended policies, because candidly, a lot of this stuff, we believe, is better left to policy rather than legislation.
Mr. Chair,
Senator Limmer.
how wide did your organization expand? Was it only county attorneys, or did you invite law enforcement to participate in this discussion?
County Attorney Johnson.
Thank you, Chair Latz and Senator Limmer. It's a multi-step process. We wanted to make sure the county attorneys were in alignment on things, had come up with a written product, and then the next step in the process is to ask our board for authorization to discuss the working draft of that product with all of the law enforcement stakeholders, in particular, Sheriff's Association, Chiefs Association, MPPOA, LELS, city attorneys, the Attorney General, and the BCA. There may be others that we identify down the road, too.
And so, Mr. Chair, so they did participate in building what you have so far in recommendations.
County Attorney Johnson.
Thank you, Mr. Chair. Senator Limmer, we're at that stage right now where we're asking our board, our work group is asking our board for authorization to disclose the working draft to law enforcement so we can come around the same table. But we've already had a preliminary meeting as some of this legislation was coming on board with them, and they've posed some questions to us, which we're preparing answers to. So it's literally a work in progress right now.
Mr. Chair,
Senator Limmer.
as I've been listening to this, the case originally started in 1963. I might have been on the same playground with with Bob Small, but I was in first grade and he was in eighth. But anyway, I'm kind of surprised that legislators haven't addressed this situation for these many years. The question that I may have is, and as I've been listening to this conversation, I did go in the direction of whether or not prosecutors should be the ones to keep this in their own silo, as far as making broader policies for an entire state group. But my difficulty is that this triggers into labor law, it triggers into judicial process, raises constitutional issues. Therefore, it does require legislative review, as well as perhaps creating a framework for these policies to be maybe finer tuned by the individuals, the stakeholders involved. But I don't know if that's ever going to come about, so it may have to land in the hands of the legislature. I wish this issue would be done, because we've had to address this, and
Oh, we're just getting started,
I
Senator Limmer.
know, but getting started has taken 3 or 4 years so far. And so I can only, my sense is that it's going to take a lot longer if we don't come to some kind of conclusion, a set of framework or parameters to work within. And I hope that each occupational group can come to terms with it. Could I ask the question, when do you think you will be, Mr. Johnson, will you be inviting law enforcement to participate in a meaningful way and get their reaction to some of the proposals you've already arrived at?
County Attorney Johnson.
So it's been the topic of discussion at the last 3 board meetings at MCAA, and I expect that at the one next month that it's my hope, I'm asking for it, we'll have that approval to provide them with our draft and to get comments on those things. That draft would contain many of the issues, notice, opportunity to be heard, certain things that are part of the existing iterations of the legislation. Set that aside for just a second in terms of sharing drafts. I mean, as I indicated to the committee, we are literally in the midst of working on responses to their questions, so we're not waiting to work with them until we get permission to share with them our draft policy. We are working with them on our issues and concerns with respect to this legislation, things that we're in a general agreement with, things that we want to refine, and things like that right now.
Thank you.
Senator Westlin. And then we got Senator Croon, and I got a question or two, and then we're going to have our 3 other witnesses come forward. So let's try to be succinct if we can.
I
Thank
will
you.
do my best, Mr. Chair. I make no promises. So I have a question. I know, I don't recall which of the 3 of you mentioned, but there was discussion of county attorneys or prosecutors' offices having kind of a designated Brady-Giglio person. How common is that? I'm going to assume there are probably some agencies that don't have the resources to do that, but can you talk about how many agencies do have that?
County Attorney Magnuson.
Thank you, Chair Latz. Senator, it is, that is, I think, best practices, and I think it's quite typical, because it doesn't have to be, a full-time job. You can have people wearing multiple hats. Typically, it's the chair, or the head of the criminal law division, or your first assistant. Sometimes if it's a county attorney with only one county attorney, that person wears all the hats. But I think it is important, and if one possibility to look at this would, for legislators is, to require policies. And not only policies for prosecutors, but I would be interested to know how many of the law enforcement folks that you've been talking with have their own Brady-Giglio policy. Every one of them should have a Brady-Giglio policy, and everyone should have someone designated to be communicating with prosecutors about things that, updating prosecutors on developments in their department.
Senator Westlin.
Thank you, Mr. Chair. Thank you so much. Chief Werner briefly mentioned a memorandum of understanding that certainly the Maple Grove Police Department had with the county attorney's office that outlined a process, a step-by-step process. Are you familiar with that? And if so, is that kind of a process that may be workable? Just for those who don't have the information, the Maple Grove PD Internal Affairs Unit was to identify any administrative file with sustained findings, whether or not discipline was imposed against any past or present Maple Grove PD personnel. It's there was a committee that met. They went over all of those files. If there was any dispute about whether material in the file was Brady or not, it was classified as Brady, and then it identified what the categories of Brady material were, et cetera. And so if you are familiar with that process, do you have an opinion about whether that is kind of what we should be aiming for?
County Attorney Magnuson.
Thank you, Mr. Chair, Senator. I think the exact mechanism that happens between a law enforcement agency and a prosecutor's office is going to vary a little bit. In Washington County, we have a policy, I have it, that lays out almost everything that's in the memorandum that you're referencing. So it doesn't necessarily have to be via a MOU. And we're also working with law enforcement to look at their Brady-Giglio policies and comparing them to the other ones and ours, and making sure that everything kind of syncs up and work together. So it's not just a top-down or a prosecutor-driven function.
Senator Cruin.
Thank you, Mr. Chair. Trying to look at this from a broader perspective. Both of the bills are a little bit different, but at their core, it's the legislature mandating policies upon the county attorney's office. County Attorney Johnson, you mentioned earlier that you saw some separation of powers issues in these bills, but you didn't elaborate on what those were. Do you care to elaborate on what you think the separation of powers issues are in these bills?
County Attorney Johnson.
Mr. Chair, members of the committee, Senator Cruin, I think a classic example of a separation of power issue, and it might even get into a prosecutorial immunity issue, is creating a district court review of a prosecutor's decision as to whether or not something meets the criteria for Brady or Giglio, and then ordering that prosecutor to take something off of a database or a list or something like that. I mean, I think that that's a unique prosecution function. And I get concerned about, the review kind of component of that, especially since that was lifted out of an Iowa law that was really more of an employment-related context, and it actually would create, and this is one of the things that we'd like to talk to law enforcement about, but it would create a public hearing about potentially private data, whereas in the, that would frankly pit potentially a law enforcement officer against a prosecutor and allow the judge to be able to tell a prosecutor what their constitutional and ethical obligations are. And that doesn't that doesn't change the constitutional or ethical obligations of the prosecutor. So even if you have to strike it from a list or a database, what happens when the next case comes down the pike? So those are some of the unique kind of issues that we want to work through with law enforcement on some of these drafts.
Senator Crowe.
Thank you, Mr. Chair, and in the interest of time, rather than do this all with a bunch of different questions, I'll just kind of have some thoughts and then throw it to you to see where I might be going right or wrong, to help me understand kind of the whole situation here.
Senator Crowe, I think what I'm going to do in light of time, I'm going to ask you to make your statements, and then we're not going to have any feedback at this point. You can go offline if you wish for further follow-up.
Very good. Thank you, Mr. Chair. So it seems like, well, then if I do have one more question, then, is there any, you mentioned you're in the middle of a process of establishing recommended policies, and you think that some of these things are best left to, or most of these things are better left to policy, some to rules of practice, some to training, and then maybe there might be some basis for legislation at the end of that, if I'm understanding your testimony correctly. But these bills are directed at county attorneys, and it sounds like everybody should have a policy, all the law enforcement agencies and everything, but these bills are directed at county attorneys. It seems like, and I'm very sensitive to police officers who maybe have been caught up with some abuses by some county attorneys' offices. But then it sounds like county attorneys are taking their Brady-Giglio obligations very seriously, but are not abusing them. As to the timeline, because basically you're asking us to wait until your work is complete with the county attorneys and coming up with recommending policies and that sort of thing. And Senator Limmer's point is this is taking a really long time, and I'm trying to figure out why the process is taking so long, and then now after you get it, then you're gonna bring law enforcement in. Is there a problem going on with the county attorneys that is preventing them from coming to some sort of alignment? And why weren't the police officer, the law enforcement partners brought into this earlier and kind of do it at the same time so we could have kind of a negotiated end of this sooner than starting again now, once you guys are done, then we're gonna bring law enforcement in, and it seems like it's gonna drag on for a long time. So can you just kind of shed light on what's going on and why this is kind of taking so long?
All right, Senator Crowe, I'm going to treat that as a rhetorical question. We're not going to have three other testifiers have time to testify. So we're going to leave that hanging out there for the world to contemplate. Thank you, three of you, for testifying.
Happy to address it offline.
We're going to ask William Ward, State Public Defender, to come forward, Claire Deagle, Director of the Professional Standards Division of the Hennepin County Attorney's Office, and Sheriff Brian Welk from Cass County. All right, Ms. Deagle, you got to the table first, so we'll start with you.
I thought going on this side would mean I wouldn't have to go first, but thank you, Chair. Happy to do that. Good afternoon, members of the committee. My name is Claire Deagle. I'm the Director of the Division of Professional Standards at the Hennepin County Attorney's Office. That division houses our Brady team. We have 3 full-time staff members, one of whom is an attorney, solely focused on this issue. They solely work on Brady-Giglio compliance and that making sure our prosecutors are complying with their constitutional and ethical duties, and that we can maintain the integrity of our convictions by guaranteeing that the defendants have a right to a fair trial. We are also members of the MCAA. I want to make that really clear. And like the MCAA, we oppose these 2 bills today. We are grateful, however, for the hearing. Thank you, Chair, and thank you both of the senators who brought these bills forward, because it's bringing this really important issue back. And now it appears that there's recognition that this is not a Hennepin County issue. This is a statewide issue, and so we are very grateful that this committee is looking into it. And I'm here today to provide some data and some facts that this committee can use to make an informed decision about what this committee should be spending their time on. The issue here is not about solely officers' rights under the Privacy Act, under any labor agreement. The real issue here is about access. Prosecutors do not have access to this information that we need, that we are required to disclose. And we don't have when we don't have access, that affects the defense, that affects law enforcement, it affects our victims, and it affects our courts. That is the issue underlying all of this. And last year, Chair Latz introduced a bill that would do exactly what is required to fix a lot of these problems. It would amend the Minnesota Government Data Practices Act to allow law enforcement to share this information with us in a way that is timely. That bill has been introduced in the House as House File 1576, and I am hopeful that it will be introduced again this year. So why do I think this is about access? That opinion is based on data that we have. Hennepin County, everybody knows, largest office in the state, largest number of prosecutions. We have over 38 law enforcement agencies in the county, 38 law enforcement agencies. In the past 6 months, the Hennepin County Attorney's Office has filed 393 motions for court orders to ensure that we can review private data about mistakes or misconduct by law enforcement officers that we would be required to disclose under Brady-Giglio. 393 motions. That's why we have 3 people working on this. In those 393 motions, that's not just about one officer. In one motion that we filed last week on a homicide, there were 27 officers. 27 officers. So the chiefs that you see sitting behind me today in Hennepin County, they probably don't love that I'm calling them out, but those are the people getting these orders. Those are the people getting these requests. So that chief, who I won't name, who got that order about the homicide trial, that trial is set in the next 6 weeks. That individual chief, or whomever the authority is delegated to, has to go back and look at 27 officer files and figure out what to share with us, and then we have to review it, and then we have to decide whether it needs to be disclosed. It is an unworkable process, and it disadvantages everybody here. In those 393 motions that we filed, guess how many objections we had from law enforcement? 2. We had 2. And one of them was because the court decided to use language that we did not ask for. When the objection was made and the court used the language that we had asked for, the objection was resolved. The second objection occurred because an officer was subpoenaed, and then we were going to withdraw the subpoena because we didn't need the officer to testify anymore. And the city attorney in the objection said, this person's not going to be testifying, you guys are going to withdraw the subpoena, therefore you don't need to see this data. Fine. So I do want to just briefly correct the record with regards to this case that Chief Warner and Mr. Draper spoke about. To answer your question, Senator Clark, that order came out February 7th, 2024. It was not about disclosure, it was about admissibility. And the court in that case did exactly what we had asked for, which was review the information in camera. So I'm happy to provide more information about specific cases, but I don't want to spend this committee's precious time and the opportunity I have here debating what happened in a case from a year ago, when we have data to show that the issue here is access. It is these motions that are flooding the courts. It is these motions that are continuing trials, inconveniencing our victims, violating potentially the rights of defendants to a speedy trial. That is the issue. And to my knowledge, and I've talked to folks in the office who've been there a lot longer than I have, to our knowledge, no one in Hennepin County, no officer has been terminated for being placed on a Brady list, which we do not have a do not call list. There are definitely officers who have been terminated who are on our Brady-Giglio list, but they have been terminated because of the underlying conduct. So I was a little relieved to hear that it was identified that was Cloquet and not Hennepin County. But I have the arbitration order from that case, which was issued in 2019, and it states that the discipline involved there was about truthfulness. So that doesn't, I'm not here to say that officers should have lost their job or anything like that. But I think what the lack of objections shows that we can definitely provide safeguards for officers, and we should. We should do that. And the legislation that's been introduced in the House on data practices and the legislation that Chair Latz introduced last year actually had some protections in there, because it basically allowed any chief, if they think we are going too far in asking for information, they can say, go to court, get an order. That legislation still allowed that. So I have told all of our chiefs, I'm happy to come out, I'm happy to talk to you. The city attorneys aren't gonna let me look at your private data. They're just not gonna do that. And with respect to the comments about the MOU, we have MOUs, we had MOUs, they were all different. Because as County Attorney Magnuson identified, law enforcement agencies have different needs and they have different interpretations of the law. So for that reason, we are opposed here, but we also hope that any future legislation really addresses the main issue, because the bills proposed here today simply go too far in expanding the rights of law enforcement. Doesn't mean they don't have rights, and we have been able to find ways to protect those rights, and you can see that in the lack of the objections, but really the focus needs to be on accessibility. Thank you for your time.
Thank you, Ms. Deagle. We're going to go to Mr. Ward now from the Board of Public Defense and then the County Sheriff.
Thank you, Mr. Chair. Members, my name is Bill Ward. Just a reminder, I'm the State Public Defender for Minnesota. My office represents clients in all 87 counties in adult and juvenile court in over 130,000 cases a year. And these Brady-Giglio issues we're discussing affect my clients dramatically. These bills actually infringe on our ability to zealously represent our clients, as well as I believe they are unconstitutional on their face. I would agree with Mr. Magnuson's comments earlier, so I'm not going to actually kind of truncate what my points are going to be. But it sounds like these are in response to some labor dispute, as well as the relationship between the elected county attorney for Hennepin County. And for those of you who know my relationship with the elected attorney, the fact that I'm on their side should say something to all of you on this. That I'm sitting with the county attorneys in this room on their side should tell you something about these bills. And the fact that MACDL also has concerns should give you some self-reflection as to kind of holding back here a little bit as to what you're trying to accomplish. Lest you think that Brady-Giglio isn't a big deal, just yesterday, the United States Supreme Court overturned a murder conviction based upon a Brady, what they call NABU violation, in a case called Glossop versus Oklahoma. That individual is on death row for 20 years, and the Supreme Court finally found that the prosecution violated its constitutional obligations to correct false testimony. That's Brady, and that's Giglio. And I can understand, nobody wants to be called a liar or branded a liar, right? I get nobody wants to be on a so-called list. I understand as a human being that I would not want that either. But the reality is, it's not the prosecutors who did that. It's the person, what they did, what they said, their specific acts of conduct. And the reality of these discussions is about Giglio, right? It's about, in Minnesota and frankly the federal government, you can impeach someone on specific acts of conduct, things that they said. So Chair Lass earlier said examples that may be somewhat esoteric. If someone lied in a rental application, that's impeachable. You can impeach them on that specific act of conduct in a criminal case. So it's not about setting up these policies and rules. That's the Constitution. Those are the case holdings. I would suspect, and I'm not going to go through the Brady-Giglio list so you know what it is, but the definitions truly do differ between the two bills. But I would suspect that people keep a list, if you will, and it's really about record keeping, so the prosecutors don't violate their duties. If they violate their duties, they are subject to ethical responsibilities as well. I would also tell you, and neither Mr. Johnson or Mr. Magnuson was able to answer this question, I know the vast majority of prosecuting authorities do not maintain a quote-unquote list. They don't. But those who do maintain that list, do you know what their obligations are with that information? If they have it, they have to tender it. There's no delay in it. There's no questioning it. If they have it, they have to tender the information. If they don't keep a list, what are the responsibilities? If they have it, they have to tender the information to the defense attorney. And again, we represent over 90% of the cases in the system in the state. I don't need to speak for the prosecutors, and I won't, but their obligations are under federal and state constitutions, state discovery rules, the Minnesota Rules of Professional Responsibility, to disclose material to the defense, including impeachment material that goes to the credibility of a witness in a timely manner. The rules of professional conduct, Rule 3.8, special responsibilities of a prosecutor, make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigate the offense. That's the ethical rules that they must follow. And these bills would delay that in a timely way. I suspect nobody facing me right now has ever spent a day in jail. I suspect I'm right in that. My clients do, right? Well, I have too, so maybe a couple of you have. Actually, we've talked about this once before. You and I had that conversation. My apologies, Senator Howe. I mean, and so have I. But for those of you who haven't, it's not a generally nice experience. But the people we're talking about and who are intimately involved in these decisions are sitting in jail for longer periods of time while these orders are being discussed by the court or while there's delay in distribution of the material we should get almost immediately. They are in jail. Or they have the albatross of the case hanging over their head, whether they can move out of state, whether they can go back to see their wives or be with their children. That's who's affected by these rules. The bills, and I'm not going to go through them, they've already been discussed, they set up this multi-state process. And this multi-state process seems to apply even to public issues as well. And the reality is that multi-step process, I apologize, is going to cause delay and does violate the ethical responsibilities of the prosecutors. Senate File 1813, it does at least recognizes the duty that you must disclose whether somebody wants to challenge that they're on that list or not. But it's still, the language isn't strong enough to understand, really what should be done. It's still proposing a statutory framework, but it oversteps the constitutional rights of the accused pursuant to Brady-Giglio, its progeny, as well as the rules of ethics and the rules of criminal procedure. My question to you, and I'm not trying to be facetious, this clearly is involving police officers who don't want to be branded in some way on actions that they did or on things they think are mistakes, but certainly could be used at some point in impeachment. I've been teaching trial advocacy and cross-examination impeachment since 1995. I am older than Brady. I was born in 1960. I've been doing this for a long time. And the sky's the limit on this stuff, as it should be, to go to the heart of whether somebody's credible when they're testifying against my clients and trying to take their freedom away. But if it really is about having a list and branding somebody, then maybe we should also have a bill introduced to protect the informants or other lay citizens. Maybe they don't want to be branded as being a liar or someone who can't be truthful either, but I suspect it's not about that. Trust me when I say to you, Brady-Giglio violations occur all the time in this state. They just do. For a lot of the reasons that have been discussed at this table today about not having kind of a uniform policy throughout the various prosecuting agencies throughout the state. But our focus should really be on making sure that the violations don't occur so we fully protect the rights of the accused. Instead, these bills are focusing on the officers who feel they've been wronged because the prosecution followed their respective oaths and ethical responsibilities. The easiest way to not get on a list, don't lie. Thank you.
Sheriff Welk, Cass County Sheriff.
Thank you. Good afternoon, Chair Latz and members of the committee. Thank you for the opportunity to testify today. My name is Brian Welk, and I serve as the elected sheriff of Cass County. I'm here today on behalf of the Minnesota Sheriff's Association, representing the 87 elected sheriffs across our great state. We recognize the significance of this issue before the committee and the importance of finding a solution that works for all stakeholders. Law enforcement agencies across Minnesota need a clear, consistent, and fair process regarding Brady-Giglio designations, one that protects due process, ensures transparency, and maintains public trust. Right now, there is no uniform standard across the state. The handling of Brady-Giglio matters varies not just from county to county, but even between municipalities and their prosecutors. This lack of consistency creates uncertainty for law enforcement officers, sheriff's office, and the communities we serve. A standardized framework is essential to eliminate discrepancies and ensure fairness in how these cases are managed statewide. It is essential that when a Brady-Giglio designation is made, the responsibility falls on the appropriate authority to notify both the affected deputy and their sheriff's office. Direct and timely notifications ensures that all involved parties are aware of the designation and have the opportunity to respond accordingly. A lack of clear notification procedures creates unnecessary confusion and undermines the ability of agencies to address the matter effectively. Additionally, sheriffs recognize that disciplinary decisions should not be based solely on the existence of Brady-Giglio designation, while chief law enforcement officers must retain the authority to conduct independent investigations and take disciplinary action when warranted. Those decisions should be based on department-led findings rather than an external designation alone. The designation itself does not necessarily reflect a full and fair assessment of the deputy's conduct, and agencies must be able to review the circumstances independently to determine appropriate action. Finally, due process for deputies is critical. Law enforcement officers must have a clear and fair avenue to challenge a Brady-Giglio designation. The ability to contest such a determination ensures that deputies are afforded basic procedural protections, reinforcing both fairness and accountability within the system. Establishing a transparent and consistent process benefits not only the deputies involved, but also the integrity of the law enforcement profession as a whole. The Minnesota Sheriff's Association looks forward to working with our justice partners and our legislators to refine and strengthen the bill as it moves forward. We appreciate the committee's time and effort in addressing this important issue, and we stand ready to collaborate in developing a workable, balanced, and effective solution for law enforcement and the communities we serve. Thank you for your time.
Thank you, Sheriff. Are there any questions from members of the committee for any of the testifiers at the table? Senator Westlin.
Very briefly. Thank you, Mr. Ward, for your comments. As you know, I sent you my bill beforehand.
Yes, you did.
And I will issue the same invitation. My interest in bringing this forward, and I believe the same is true of Senator Seeberger, she can speak for herself, but I think the interest in bringing this forward was the lack of clarity, the lack of uniformity, and really needing to make sure that everybody understands all the way up and down the system what their obligations and their duties are. And I think I will reiterate again, the clear constitutional requirement is to provide this information. The defense has a right to the information. And again, I think it's trying to make sure that there's at least some process and some uniformity. I think my understanding is there had been a process that maybe was working between one of my chiefs and the county attorney's office. Again, I look forward to having further conversations with you. You're passionate about this, as you should be. We all should be. This is about having a justice system that works from beginning to end for everyone that finds themselves involved in the system. And I look forward to working with you.
There are a lot of threads through this testimony. Really appreciate the testimony and the work that everyone's put into this. Due process is pretty paramount under our Constitution, and that cuts for all the participants in the justice system. So whether it's law enforcement officers or defendants, and sometimes due process gets balanced with efficiency and timeliness as well. So maybe some balancing here. Sometimes the legislature is not the right place to solve problems. Sometimes it is in a more narrow way, sometimes more broadly. And so I think all these questions are going to be before us. And I think one of the other questions before us is the question of uniformity. And I was going to say versus maybe community standards, but I don't think that'd be the right way to phrase it now, since I think it's not so much a matter of community standards as it is individual county attorneys, prosecuting attorneys' assessment of what their constitutional obligations are and their ethical obligations, which ultimately has to be a case-by-case basis determination. I don't think you can do any more than cite the rules for the ethical duties, and you cite the constitutional provision, and then any particular case that's going to get evaluated on its own merits. But how we work through those in terms of setting statewide standards or policies or guidelines or best practices or a statutory requirement for uniformity and definitions, I think these are all questions that are going to have to be resolved. I want to encourage all of the stakeholders that are here today to be willing to sit down and to talk with each other, to work through some of these issues. We're not going to reach any conclusions without that happening. My office is willing to serve as a convener if that's helpful. My staff are just surprised by my comment now. They may not appreciate it. But if that's Senator Westlin will bring baked goods, homemade baked goods. But we need to address this, and I don't think it's helpful for us to push this off for another year if we can avoid it. So, well, the county attorney's been working on it since 2024. Well, it's February 2025 now. I don't think we can wait for Bob Small to be around next year to deal with this. Although I'm sure he would be and still be willing to do so. Former Assistant U.S. Attorney and Judge Small. Brings a lot of hats to this conversation. But these are all really, really important voices to be at the table. So I'm going to encourage the people to be open to conversations with everyone that's got a stake in this so we can make the system work for everyone that's involved in the system as well. With that said, we don't have any formal plan right now to bring any of these bills back before the committee, but it's my intention to try to bring something back before this committee to act on this year. We don't even know when our deadlines are yet, so we're operating in a state of ambiguity. But with that said, I suppose that's in some sense the kind of state that Senator Seeberger works in when she's ice diving in preparation for emergency training, right? So we're getting pretty good at that. We'll keep it up. Thank you all for your testimony today, for your work on it. We are adjourned.